Delaware is implementing new rules in shareholder litigation, and based on a recent article, they think it may chill some of these lawsuits against companies. So, from the perspective of being a business lawyer that often represents companies, this looks like a good thing. But often in my practice and in the real world, I also end up working with owners of the companies, right? Sometimes I represent a company that owns part of another company. Sometimes I happen to represent people who, are executives in one company but own part of another company. So these new rules coming out of Delaware should be of interest of anybody who is playing in the business law space. And so if you're a business owner and a business leader, we need to take a look at this because Delaware is kind of the leading jurisdiction on corporate law. A lot of the Fortune 500 is incorporated there. Many private companies, particularly those that are backed by private equity or otherwise, are incorporated in Delaware. And so what they do becomes important, not to mention that a lot of other states often piggyback off of what Delaware does. So when Delaware does something, it's not uncommon in the coming days, weeks, months, and more likely years, it usually has some lag time, that other states jump on and do what they're doing as well. So the trends we see in Delaware may well be the trends that come to other states. So even if your company or the companies you work with are incorporated in a state other than Delaware, what is happening in Delaware may well be relevant. So let's jump into this new rule. It's coming via the court, just released on Monday of the week of recording. So we're recording in late September of 2023. So this new rule is hot off the presses. Just seeing an article on it come through here. So the legal press is just responding to it. So let's jump into it. Got a Thomson Reuters article here. You will see a link in the comments. So if you go to the comments of this video and you want to read the article yourself, feel free. I always like to give people first-person sources so that you can go back and see and verify and make sure that you agree with my points of view, but also clarify any particular issues for yourself. So basically, this new court rule coming through the Delaware Chancery Court, and the Chancery Court is where a lot of business litigation goes. So different states have different court systems. A lot of states have now implemented business court systems. It's getting to be more and more common. We're seeing it in Georgia, Wyoming, and other places. And so Delaware has long had its Chancery Court, which has effectively acted as a business court. It's not called as such. It does deal with some other things, such as property matters and other stuff. But the Chancery Court has long been known as the business court, and it's been very efficient. Other courts have wanted this. So we have a new Chancery Court rule that is adopted. And essentially what it's talking about is shareholder litigation. So what we have happen a lot of times, particularly with big companies, but also with small companies as well, is shareholders will not be happy with what's happening within the life of a Delaware corporation, right? They'll think that the owners are taking advantage of them. They think that something's done wrongfully. This talks a lot about high-end litigation, particularly with respect to disclosure filings and other things. So at different times, shareholders may want to challenge what's happening in the company. And those are typically styled as derivative suits. So the shareholder's not necessarily bringing a suit for themselves. They're bringing a suit on behalf of the company. And now what's getting layered on here in Delaware is a special rule when one plaintiff changes to another. So if we have some complex litigation going on and we've got a plaintiff, somebody who brought the lawsuit, and for whatever reason that plaintiff is now to the point where they want to settle, but the other claimants, the other people who are in the lawsuit, are not happy with the settlement, they want to take over, a new rule is going to kick in that's going to require adequate security. So that taking over plaintiff, the second plaintiff or the follow-on plaintiff, is going to have to basically put money or property up with the court to potentially cover the legal expenses for the corporation or defendant if the litigation continues to move forward, and essentially if they would be deemed to be the loser. Now, we've seen this in other types of litigation. There are times where the court will require people to post bond or security, right? It happens in the tax court. And sometimes if you need to appeal something, you actually have to post the money or pay the money over and then try to get it back, right? There are different situations where our court systems have required this type of situation. And sometimes also in other states, with respect to settlements, there's a procedure whereby if there's a settlement offer and the settlement offer is rejected and somebody continues to follow up on a lawsuit and they end up winning less than the settlement offer, the court will actually then tack the attorney's fees of the person who offered a settlement offer, the defendant. They will tack their attorney's fees on to the person bringing the lawsuit. So this is an incentive to settle, right? It is, you'll settle at this price because if you take the dice roll for a bigger amount and you don't get it, not only do you not get the bigger amount, but now you also have to pay the other side's attorney's fees. And the thought is, from an economic standpoint, is it encourages more favorable settlements. Now, this is an end run or an attempt to really get to the same type of thing, I believe, right? So they're going to say, hey, if we've got a settlement and some of the plaintiffs are getting out and you want to keep moving, you're going to have to put money up here to make sure that you really double down on this. And so it adds cost and expense. And it may lead to corporations not having some of their actions challenged, right? And that is one of the concerns discussed by some of the lawyers here, is that there may be times where litigation will be stopped or not go forward, and that will potentially lead to issues downstream. Now, most of us say, hey, litigation is expensive, particularly if you're like me and you're typically working with companies, you're working with businesses. You don't want this litigation hanging around. You don't want the expense of it. You want it gone and over with, right? You want to move on with the life, particularly a transactional lawyer like myself. I'd rather be doing deals than dealing with litigation, which is all about the past. We're more worried about the future. This, while it may end up getting rid of some litigation, the concern expressed here is that it's not really going to allow people to challenge things as well. This posting of security may well be a situation where people say, hey, I don't want to post this security, and I'm just going to back out of the lawsuit, or I'm going to settle sooner. I can't take the economic risk. That's going to mean less continuation of lawsuits, and that people may get out sooner. And while that may lower litigation costs, what it does do is it lowers the amount of precedent out there, and it means that we may not see as many situations. We may not get as much developed case law. We may not learn what other people are doing, and we may not get the guidance that we need as companies to understand how we should shape our behavior. Because behind the scenes, a lot of times what's happening is the lawyers involved are looking at the cases in the courthouses, and they're saying, you know, what has happened? What were the very specific facts? How they match up to the facts that I'm dealing with right now, and how do I direct things, right? So when I get into complex situations with my clients, that's often what I'm doing. I'm pulling out the Delaware statute. I'm pulling out the Delaware case law. I'm looking at how similar situations have been handled. I read the facts of those cases, and then I'm tailoring things. The more cases there are out there that have more different facts, the better I can help my clients with planning. And while I don't want my clients to be the ones that set the litigation and be the ones that set these precedents and set the standards, what happens, though, is that I look at what other people have been through. So if there's less lawsuits and there's less developed cases, I'm going to have less guidance from my clients. It also may mean that companies get sloppier. So in those cases where, as I mentioned at the beginning, sometimes I have a company that owns part of another company, or sometimes I have an executive that I've worked with that wants to work with me, and then I am now on the shareholder side of a situation. Well, if I'm on the shareholder side, I want as many tools as I can get a hold of. And this here is basically potentially taking away a tool. And while it's not saying the litigation can't continue, and while it's not stopping the litigation directly, it is economically, adding to the wheels of justice and making it more difficult to bring things forward, which means as a shareholder representative, when I'm in that case where I need to work for a shareholder, I've now got less tools in my tool chest, or at least less affordable tools available. I may still be able to bring the lawsuit. I may hit a situation where I have multiple plaintiffs and some of the plaintiffs bail out. Then does my client want to continue forward, right? So, and rarely in my case do I actually get to litigation. Usually when my clients go to litigation, I bring in a litigation firm. What I typically do is plan, and I get involved in these things before they even see a litigator's desk. But again, knowing how the path of resolution is really impacts how I do things. So this is a very important thing, and it's going to have some downstream public policy consequences. And it's a lesson to us of, A, why we need to watch this stuff as business owners and business leaders, because we need to know what's the potential for risk of litigation, what the cost of litigation would be. But it also teaches us that these courts are really directing a lot of public policy. Even in a state like Delaware, with a very active legislature that's updating the laws regularly, here the court, through court rules, is actually potentially changing how litigation will proceed and how it will change. Now, what can happen in Delaware, and what we might see, is that at some point the legislature may get involved. Often when the courts get involved in Delaware, if enough people get upset, then the legislature gets upset. So this is going to be a battle. You can see it in this Reuters article that there is a challenge between law firms that are typically defending corporations and law firms that are typically suing corporations, right? So the world is largely divided. Of course, it's never 100% clean because different facts, different situations. But there's law firms that will routinely bring these lawsuits, and there's law firms that typically defend these lawsuits. So for the law firms that defend these lawsuits, they're probably happy. They've got a win. For the law firms that bring the lawsuits, they potentially got a loss. They may not be able to bring as many lawsuits, may fear having lower legal fees, but they may fight this on another front, which is the legislature. So more to come on this. If you're enjoying this content, you like this, consider subscribing to our channel. We got a whole library of past videos here. We'll be bringing you more videos with updates about business and business law. If you have suggestions for videos, go ahead and drop them below. Don't put anything in the comments that is confidential. Other people may see it. I enjoy seeing your comments, and I do appreciate them, but don't put anything there that you don't want other people seeing, because that may be a problem. So, all right, folks, thanks for tuning in today, and I look forward to joining you for another video soon.